This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why crime does not allow an insurer to pay and why crime never does pay, and that it's okay for an insurer to withhold coverage for criminal acts because it disincentivizes criminal conduct. Safeway Insurance Company sought supervisory writs from the judgment of the lower court, which denied its motion for summary judgment. In Damian Harris v. Safeway Insurance Company, a October 25, 2023 decision of the Louisiana Court of Appeal, the Court of Appeals resolved an insurance coverage dispute over a criminal acts exclusion. After a motor vehicle accident which occurred on April 10, 2019 in Abbeville, Louisiana, plaintiff Damian Harris, a passenger in a 2009 Toyota Camry, being driven by defendant Justin Rosette, collided with a pickup truck while the Toyota was running from the police. The Camry was covered by an automobile insurance policy issued by Safeway. Officers from the Abbeville Police Department were in pursuit of Rosette with sirens and lights on the police cars were activated, and the facts established that this was a high-speed pursuit. Rosette ignored a stop sign at the intersection and collided with the vehicle being driven by Aaron T. Dirk. Rosette was arrested for aggravated flight from an officer and possession of narcotics at the scene of the accident. The plaintiff sustained multiple injuries. Safeway denied coverage based on a policy exclusion clause included in their standard contracts for criminal acts. Following the denial of coverage, plaintiff filed suit against Safeway and Rosette for damages arising from the motor vehicle accident. Plaintiff and Safeway filed cross motions for summary judgment on the coverage issues. Both motions were denied. Safeway argued at the time of the collision Rosette was engaged in and or committing several criminal acts. Safeway noted that before the collision occurred, Rosette had been chased by numerous police cars for several blocks through parts of Abbeville. Safeway also noted that Rosette disregarded several stop signs while speeding excessively, and the specific cause of the collision was Rosette ignoring another stop sign at the intersection. Therefore, Safeway argued Rosette was in the commission of a crime under Louisiana Revised Statute 14:108.1. Plaintiff countered that Rosette was not engaging in a criminal act in the moments right before the collision. Although coverage exclusions generally do not comport with the policy of granting protection for injured persons, the exclusions in the Safeway policy served a separate public policy interest of prohibiting persons from insuring themselves against their own intentional or criminal acts. Withholding insurance coverage for intentional or criminal acts helps to disincentivize such conduct, which in turn serves the purpose of eliminating reckless and irresponsible drivers from the highway. Whether Rosette was contemplating discontinuing the flight from police as the trial court implied, the facts were clear that the accident occurred immediately after he again ran through a stop sign and collided with Mr. Dirk. There was no question of fact that Rosette ran into Mr. Dirk's vehicle while intentionally fleeing from a police officer, which is, of course, a crime. The Safeway policy in this case clearly provides that damages arising out of the use of an automobile, quote, while being operated or used in the preparation to commit a crime, commission of a crime, and or flight from a crime, other than a traffic violation are excluded from coverage. Therefore, the Court of Appeal concluded that Safeway's writ application was granted and summary judgment in favor of Safeway was ordered. In my opinion, liability insurance by definition provides coverage only for fortuitous or accidental events. Running from the police in a high-speed chase while blowing through stop signs and colliding with an innocent driver is a criminal act in Louisiana. Rosette was running because he had illicit drugs in his car. Regardless, both crimes were going on at the time of the accident, and that the driver had a subjective intent to avoid the accident and was convicted of multiple crimes that resulted in the injuries that were the subject of Mr. Harris's injuries should have and did support the application of the collision and the application of the exclusion. There was no fortuity, and the acts of Mr. Rosette were criminal and excluded. It just doesn't pay to commit a crime and expect an insurance company to support you in a suit by those injured by your criminal conduct. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you will receive notice of every blog posting, usually 5, sometimes 6 a week, and access to the more than 4,650 blog postings. You can also subscribe to the videos on YouTube and rumble.com, also free. And if you found this video and or the blog posting to be useful, please tell your friends and colleagues so that they too can subscribe. And if you're interested in more detailed and extensive coverage of insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Locals Community or my Substack publications. Thank you for your attention.